affidavit that he reviewed the offering plan. So they were clearly aware of what they put in there, and I think I mean, it would seem incredible to me that he had no awareness, or Constantini had no awareness, that people who were about to pluck down $4 million for a unit were going to rely on something as elemental that the apartment would heat in the winter and cool in the summer. It's impossible to believe
everyone
that.
who contributes to the offering plan, in some way, shape, or form, if what they contribute is false, the purchaser has a direct link to that person, and under the test, the three-pronged test, and that the purchaser, in a general way, was known to be relying on it, and then that satisfies it.
Well, again, look, Judge, that's the position that the majority took. They said in their opinion that Constantini could only know in the most general way. We think that's not the case. We think that the dissent was right on when they said that if we couldn't rely on it, who could? Why was it in there otherwise?
Are you familiar with a case called Westpac in our court?
I'm not, Your Honor.
That was a bridge lender who sued for a negligent, sued an accountant because he was led to make a bridge loan. And his argument was, well, the accountant knew there was going to be a bridge lender. And as I read the case, it says, that's not enough. You got to know who it was. I mean, it's hard for you to react, obviously, in my summary. But isn't that a fair statement of the law, that you got to know who the plaintiff is?
Well,
maybe a tough test, but that's what the law says.
In this particular case, there is a pool. There are a pool of potential purchasers of a luxury condominium. That's what it is. It is defined. I can't say it any plainer than that.
Hasn't this court said in a couple of decisions that just identifying a class of potential plaintiffs isn't enough?
I understand that. But again, Your Honor, I just take it back to the fact, and I know that the court dealt with this in the earlier cases today, we're really at the pleading stage. This is not a summary judgment case. This is really a pleading case. And the way that I read your Leon against Martinez case is that you have to afford this pleading the most liberal construction. You have to give my client every favorable inference. If there's any defect, you have to look to the affidavits to cure that. And more than that, if there is a cause of action out there, not even if we have stated one, you have to sustain this complaint. And we submit, as the trial court found, as well as the dissent cogently found, in our opinion, that there are certainly more than enough allegations. The allegations, not proof, because we haven't completed discovery here yet, and we have to get, as they were saying earlier, to the courthouse door to prove our case.
What more might you develop through discovery?
Well, we could certainly. My adversary is going to tell you that I would like to know what the relationship was with the sponsor, where they took on the duty to put the plans in the offering, to put the description in the offering plan, when there was no obligation in the engineering agreement to do so. That's key to this case, and we haven't had an opportunity. We haven't had an opportunity to discover that yet.
Okay.
Thank you.
Thank you, Captain.
Have rebuttal.
Counsel?
May it please the Court, I'm Richard Lerner. I represent Cosentini Associates. I'd first like to state that I'm withdrawing the statute of limitations argument.
Okay.
Judge Smith cited a case called Westpac, I think that was the name of it. I'm not familiar with the case, but the principle is so well established in this court that there are probably many more cases that could be cited for that proposition.
Well, is your client completely off the hook?
Absolutely.
The architect can't cross-claim against your client?
Of course the architect could. If there was negligence on the part of the engineer, Cosentino Associates, of course the architect could implead or cross-claim against Cosentino Associates. Of course. There's a line of cases going back, of course, to Glanzer and Ultramares, White against Garante, where the principle is very clearly established that there has to be a specific third person who is known at the time of the contract. In Glanzer, it was the bean counter who was aware that the weight certificate would be used by the purchaser. It was a